First off, I'd like to start by thanking everybody that showed up today, and like to thank you all for continuing to support and engage in the AMFA Association. We got a lot of new ways of doing business around here, and it's been challenging at times, but I'm glad everybody's able to hang in there, and we'll get through it and get on with life here pretty soon, hopefully. Would like to start by giving some AMFA announcements and updates. We have some milestone anniversaries. We have 5 years now. We have Enbridge and PowerStep Incorporated. 10-year members are Exodus Machines and Northern Engineering. 15 years, we have Duluth Denfield High School. And 20-year anniversary is Mackinac Administrators. So thank you for your continued support. We got some new members coming in. We have Cross Anderson Construction Company, and we have Whitestone. So thank you to those two for their support. We have some updates on the following. The AMFA website has been approved to offer more value, some tools and action steps. Past events like our virtual webinars and member meetings are all there and full of current information. And it's your doorway to the collective knowledge of the Iron Range and Twin Ports manufacturing community. So I invite you all to drop in and check it out. Even though the marketing for manufacturer series is on pause, you can find all 10 of the past presentations here in the past events. The live demo, remember you can post your jobs on the AMFA website. Another tool in your recruitment toolbox. You can find the job openings link under the workforce tab. Let us know if you would like to do a virtual tour of your company. We'll help you get it out far and wide in our area. AMFA also continues to focus on our goals of educating our members, developing our workforce, and legislative advocacy. Part of the focus includes the AMFA Educational Trust, and the AMFA board is planning a beverage tasting event on June 16th at Clyde Ironworks and a golf social in August. There'll be more details to come. You can find a lot of that information on the website and through the flyers that get sent out. Right now, I would like to introduce our keynote presentation on antitrust training for manufacturers. And our presenter today is Mark Geier, a shareholder at Larkin Hoffman Law Firm in Bloomington, Minnesota. So thank you.
Okay. First, I just want to thank you for the opportunity to speak to you today and for the opportunity to talk about a topic that has been in the news a little bit lately. And that is the subject of the, I'll call it just the antitrust in general, but especially in the area of monopolies. Today, we're not going to be working on monopolies, even though that tends to be what I will call the newsworthy issue that people are often familiar with. We're just going to talk about what are the antitrust laws that actually are relevant to manufacturers and especially small and mid-sized companies. So today's agenda is that we're going to be walking through a summary of some of the key antitrust laws. We'll then also address the antitrust climate, in other words, some of the things that are coming up or that may be coming up in the near future, especially under President Biden and the current Congress. We'll discuss and explain core antitrust principles that are applicable to small businesses and especially manufacturers. And then we are going to look at an antitrust compliance policy, what it says and how you would then, I guess, circulate that throughout your company, making sure that your people are in compliance with it. And finally, we'll look at a few different questions. So before I get started, I just want you to know that because this presentation is going to be recorded and it's going to be available in the future, I need to make sure that you understand I'm providing general guidance. I'm going to be introducing topics, providing general information. I'm not going to be offering legal advice for any one specific situation. If you do have a specific question after this conversation today, feel free to send me an email and I'll be able to address it and discuss with you how much I can provide and whether it's necessary to actually do further research. Finally, I want you to be aware that when I refer today to different types of laws and whether or not people are in violation of those laws, I'm only referring to antitrust laws. There are, of course, many different laws that all of us operate under, from tax law to employment law to environmental law. But when it comes to antitrust law, it's a specific area. So if I say something is permissible or not permissible under the law today, I'm just referring to antitrust law. What is antitrust law? Well, it is a series of laws that are designed specifically to prohibit the unreasonable restraint of competition or trade. So it isn't just one area, like I said, monopoly, but actually encompasses anything that might be an unreasonable restraint of trade. These laws have been on the books in some cases for 130 years. So this isn't new law, even though it continues to be worked with by Congress and by different courts. The goals of antitrust law are to assist or give the benefit of fair prices and hopefully lower prices through competition, also to increase quality and innovation, and finally to increase efficiency. So those are the background goals that the antitrust laws are trying to promote. I like to tell people that in describing these different types of laws, to envision in a general way a football field. Your company is on the football field. It has certain competitors on that field. The field is 100 yards long, but it's almost a mile wide. In other words, it's not just 33 1/3 yards or whatever it happens to be on the professional level, but it's just an area where it has basically no boundaries on the outside. Different companies come in to compete in different parts of the field. Some of those fields are overseas, some of them are domestic, some of those are your next door neighbors. You also have different companies that participate at different levels, so that you might have one company that has 2 people on the field, somebody else has 1,000 people. Some people only work between the 20 and 30 yard line, and some people work only in the red zone. Some are really talented at throwing passes, and others are really good on defense. So different companies have different skill sets. They're competing with each other in this playing field where you're located. And all of you are competing with each other. There are only a couple of rules that I would call general antitrust requirements in this particular competition. The first is that anyone can join the competition. So you can't have 5 or 6 companies decide, hey, we're going to block the concourse and we're not going to let a new company join us, okay, or compete with us. So the first is that it's open to anyone, any company can join. The second rule is this: no 2 or 3 or 4 or 10 companies can join forces in order to compete with someone else. So just think of it as an anti-competition, as something that the laws ensure competition. And anything that is anti-competitive is potentially a problem under the antitrust laws. So if 2 companies decide, hey, we're really good, one with passing, one with running the ball, okay, why don't we collaborate, work together, and let's take out some of these other companies in a certain territory? The answer is you've got an antitrust violation. So the idea is everybody gets to compete and no one gets to join forces against others. We're going to look at different types of violations today, those that can lead to immediate violations and penalties, and some of those that have to be evaluated to determine whether or not there is an actual violation. The other item to be aware of is that you can be competing on more than one field. We often think of ourselves as having one set of competitors. In fact, you'll be working in many companies in many different areas. I was recently working with a company where I did a presentation to them. They had one group that worked with raw materials, another one that worked with processing of raw materials, another one that worked with construction materials, sales, and they were also a distributor. So they actually worked on 4 different fields. That's important because when you're evaluating who your competitors are, you have to look at which fields you're on. And when you are looking at that competitive field, you have to ask yourself, do we have any improper agreements with anybody on any of the fields where we're functioning? You're not just on one, very often you're on more. So now you've established the field, you know what the general rules are, anyone can join you, you can't team up with others. So what are the different rules that we actually work with? We have different laws. The first is a federal law. These are enforced by the Department of Justice and the Federal Trade Commission, or FTC. There are 4 general areas or laws that people refer to when we talk about antitrust. The one that people are most familiar with is the Sherman Antitrust Act, because it happens to be where you find a lot of the anti-monopoly language. But actually, the first two cover a lot more than that. And the area that we're going to focus on today is the first one mentioned in this slide. These acts, the Sherman Act and the Federal Trade Commission, or FTC Act, prohibit contracts, combinations, conspiracies in restraint of trade. Just what I mentioned earlier. There are two different types of restraints. I'll get into more of those later. One is a horizontal restraint. That's where you've got competitors who are joining forces in violation of the law or potential violation of the law. And then vertical restraints. This is when you are playing on one field and you do a deal with someone on a different field. If you're not on that field, the second field, it is a vertical agreement. Okay, so let's say that you're manufacturing. And what you're doing is you're working with an OEM. You're working on different fields, perhaps. Okay, and so that relationship is vertical. Whereas if you're talking about other job shops or other companies in your field, doesn't matter whether it's a profession or a manufacturing company, an OEM, it could be a company that provides quality services. It can be any kind of service at all. It's that field where you work horizontally with competitors, and then that's governed by the horizontal restraints. Vertical restraints are those when you're working with someone in a completely different field. The monopolies are what are governed or prohibited by these laws, but you'll see we're not even going to talk about monopolies today. I had one client where I thought they might have an issue with monopolies because monopolies, just so you're aware, can be more than just something like Apple versus Epic. It can also be something like a particular territory. Certain products maybe can only have a very limited shelf life, and they can only be transferred within a certain small radius. And if that's the case, the monopoly could actually exist at the level of a city or a certain part of the state. But we're not going to be concerned about that today. If you thought that you might be involved in a monopoly or some competitor is, I'd be happy to talk to you. The other two areas are the Clayton Antitrust Act and the Robinson-Patman Act, which again, for the most part, aren't relevant to you. The other source is state law. Now, states are a little different in that every state has its own antitrust law. And when people think about it, they overlook it unless they receive a complaint, in this case, from the Attorney General's office. So federal laws enforced by the Department of Justice or FTC, state antitrust laws are enforced by the Attorney Generals of each state. Each state has its own antitrust law. And the US Supreme Court has said that you can adopt the federal law at the state level, and many states have done that, like Minnesota. But it also says that you can also enhance penalties and sometimes change what we call the burden of proof in some transactions in order to determine whether or not a violation has occurred and what the penalty is for the violation. So just be aware, when you're in different states, you may have different antitrust laws that actually supplement the federal law. So go in with the understanding, when we're talking antitrust, we're not just talking what's going on in Washington, D.C. We're talking about what's happening in Wisconsin and Minnesota as well, or in the other states where you might be doing business. What are the costs of noncompliance? I think this is important because you are potentially subject to three different types of violations. First, for a federal violation, you would be subject to the Department of Justice. That's the FBI, for example. And all the penalties that come with federal law. Under state law, again, it's governed by what does the state say the penalties are, what are the violations, and that's enforced by the Attorney General. And again, those can be broader than what the federal law is. And finally, you have a third risk, and that is other companies suing you. And that's where you see Apple versus Epic Games right now. But that happens more frequently than people realize. Frequently, a violation or an investigation is triggered at the federal or state level, is triggered because some competitor or supplier or customer has notified the government that they think that one of their companies they're working with is somehow violating one of the antitrust laws at some level. And that triggers the investigation. So it's often not started by the federal government in the sense of the source of the complaint. It actually starts with other companies out there who don't like the way you're playing the game. That means that ultimately those companies also have an option to sue, okay? And so you're looking at a variety of risks that come with that. And in the antitrust world, you're often not just working with one person who's upset with you. It can involve literally dozens, in some cases, class actions in the worst case scenarios. But in any event, it's rarely just one company that feels they've been offended. And if the word gets out that a company might be violating an antitrust obligation of any size, and I'm referring to companies of any size, there's a risk that any of these might follow. First one is criminal prosecution for hardcore offenses. We're going to look at one a little later, which I think is interesting, out of Iowa, fairly recent. Another is triple damages, so that if the government or if one of your competitors were to sue and they were to determine that the violation is $1 million, or that the federal government determines it's $1 million, it automatically becomes a penalty of $3 million or $30 million or $300 million, depending on what the base amount was. Another is debarment, which just means you're banned from contracting. This is frequently the case if a company is found to violate an antitrust law and then tries to do business with the government. But it can also happen at a more basic level where an OEM has a policy that if one of their suppliers has ever violated an antitrust law, they just won't do business with them. That's debarment. Another is just loss of reputation. In the legal world, we know of some companies that just are almost defined by some of their antitrust violations. And that's common knowledge in their industry as well. Then I have attorney's fees, expert fees, and costs incurred by your opponents. Remember, it isn't just one, as it might be in most commercial litigation cases. Instead, it would be potentially the federal government, the state government, as well as all of the people who feel offended by your conduct and who are undertaking any kind of legal action. And then finally, your own litigation costs, which are time, attorney fees, costs, and stress. And I might just say stress is a big one because it impedes with a lot of your other business activities. So we're just going to hit right away, what is your best protection? The Department of Justice has made it clear, and courts have also confirmed, that if you take certain steps, you can reduce your risk as a company to unexpected antitrust claims. This occurs because in most companies, there's a policy, or at least there's an understanding, I should say, that no one here is going to violate any antitrust laws. There might be a certain level of just lack of awareness as to what that really means. But generally, they would say, we're not going to violate any antitrust laws. And they think to themselves, okay, we haven't been involved in any monopolies. Again, that has nothing to do with what we're talking about today. Today, we're just talking about unreasonable restraints of trade, either in horizontal relationships with competitors or vertical relationships in other relationships. And so in this case, company might not be aware of it. If the company has taken certain steps, the government will take those steps into account in determining both whether or not the violation is serious and consequently the result or the penalty that will be imposed. In a recent situation, this happened just within about the last, I think it was 5 years, there was a company out of Georgia that acquired another company, I think it was in South Carolina. When they made the acquisition, they finished the acquisition and they kept the people on board who were managing the new plant in the new company that they had just acquired. And the question became several years later, when the government investigated what was going on, the question was, are we responsible as an executive team in Georgia for what people are doing in South Carolina? We acquired the company, we kept them on board, we told them what our policies were, and it turned out that those people in the new company that they'd acquired had been engaged in price fixing and some bid rigging before the acquisition took place, and they continued to engage in it after the acquisition. Nobody knew about it at the headquarters. And the government said that the new company was liable for what was going on because the activity continued after the closing. So the new owners were responsible for what was taking place in their new South Carolina plant. But the question became, well, how responsible were they? The government said, in this particular case, the Home Office had followed these policy steps that I'll be covering in a moment, and they'd taken training. Consequently, the government would significantly reduce the penalty to the new owners. They did not cease chasing the people who were actually doing the violations, but what they said is the new owners, because they'd taken certain steps to protect themselves, approved by the Department of Justice, the penalty for them would be much less. And so the government worked out a settlement with the owners. So what is your protection? First is a clear antitrust compliance policy signed by the employees who may encounter or communicate with competitors. Now, company I recently worked with, we talked about what their policy was. Their policy is circulated to all their employees. They have about 800 or 900 employees. And in that particular case, even they, when they know a lot of the company employees do not work with competitors or ever see them, they just have a policy in place that has to be signed by everyone. But in any event, at a minimum, it should be a policy that is signed by the people who encounter or communicate with competitors. That could be socially as well as informal settings, like in different meetings with different customers. Second, they have antitrust training with records of attendance. So in the case that I just mentioned out of Georgia and South Carolina, one of the things that the Department of Justice said was they not only had a clear compliance policy and they had demonstrated that all their employees had signed it, including the offenders, okay? In addition, they had had training. And so you ask yourself, what kind of training is there? In my case, I usually just do a general training for all of the staff that the government or that the clients are looking for. So it would be any management or sales staff. But in some cases, companies actually split it up because they want to have more detail given to the management level so they understand the purpose of the laws, something like what I'm doing today, or they give it to their sales staff. And so there are two different presentations that I might do for them. Finally, some companies give a policy card, so it's just a wallet-sized card, to their sales and management to carry in their wallet or purse, summarizing the rules. Next issue is the antitrust climate. It's kind of an interesting time now because under President Trump, there was an increase actually in enforcement of antitrust laws. However, that's now accelerating under President Biden. And there is now, for the first time in years, bipartisan support for amending and strengthening the enforcement of federal antitrust laws. Senator Klobuchar from Minnesota is the chair of the Senate Judiciary Subcommittee on Antitrust, and she has previously authored a bill called the Competition and Antitrust Law Enforcement Reform Act. A lot of words. Bottom line is it's going to be very significant if any part of it is actually adopted now that she is actually the chair of the subcommittee and she's actively involved on the committee where that bill would be initiated. What are the key points affecting business manufacturers and small businesses? The big one is that they're increasing the annual budget, this is annual budgets of the Department of Justice Antitrust Division and the FTC by an additional $300 million. That was the plan, the proposal. The principal goal is to strengthen the enforcement of antitrust laws, also to add civil penalties for certain violations where there are not violations or civil penalties today. Civil penalty meaning it's a dollars and cents violation. And finally, this is the most significant part, it's to extend whistleblower protection and incentives to individuals reporting potential violations. There's a little twist in this for antitrust laws. Traditionally, when you think about whistleblowing, you think about your employees reporting a violation of some kind of law, whether it's state or federal, often involves HR or maybe some environmental releases. And in that case, the employee is protected. In fact, sometimes if you terminate the employee, it's actually a misdemeanor or more, depending on the state. But you're also, the individual also is entitled to a certain, I'll call it reward. In some cases, those rewards can be in the 6 and 7 figures, depending on the violation. In this particular case, antitrust, the actual incentives don't go to employees, they can go to your competitors. They can go to your suppliers. And so there's actually, if this change is adopted, you will actually have incentivized people that you're dealing with in your industry on your football field who would be rewarded for reporting your violations. So it really changes the field in that sense because now other people are monitoring you because there could be money involved. So that's probably the second largest issue apart from just the enforcement itself. What are we focused on today? We are focused on the specific language of the federal law and most state laws that prohibit contracts, combinations, and conspiracies in restraint of trade. Again, players on the football field, same football field, collaborating with each other. What does it mean? A contract, combination, or conspiracy means any agreement, arrangement, collusion, or understanding. It's important to know that it is not proven just by written and oral agreements. You rarely find a written agreement that violates this provision. You do find oral agreements. In other words, people sitting together and agreeing and talking about what it is they need to do next year or what they're going to do on a certain bid, or what they're going to do about a certain problematic supplier or OEM. That's where the oral agreements come in. Very often, though, there's a disagreement as to whether or not anyone agreed to anything. And so how are these agreements proven? And it's often by what we call tacit agreements, unspoken. So it would be something like a meeting, an exchange of information. That alone could be the basis for determining that there was a contract or understanding that would violate antitrust law. It's often based on what appears to just be coordinated conduct, because today that's where most of it occurs. And so when you actually read the cases that are coming out now, and we'll be looking at one in a moment, it includes oral agreements, it also includes tacit agreements, it includes unspoken conduct, and it involves coordinated conduct. It's a case coming out of Iowa. It involves some ready-mix companies, but it's fairly recent. And it's something that shows how companies try to get around the law when it comes to working on conspiracies or agreements in restraint of trade with and in collaboration with their competitors. There are two general types of restraints and two types of violations. The first restraints or restrictions are those that are horizontal. As I said, that's where you're on the same field at that time. It's included in agreements between competitors. Agreements, again, are broadly defined to even include just understandings and sometimes just coordinated conduct. It also involves vertical restraints. We'll be looking at some of those later so you can see how you have restraints and contracts, maybe with your OEMs. Violations, and this is where the issue really is where the rubber hits the road. There are two types of violations in both of these cases. Some that govern relationships with your competitors, others that govern arrangements with your other suppliers. And those are sometimes per se violations. That means they're illegal on their face. There's really no defense. And these are primarily found in agreements between competitors. So when we say per se, it means that if somebody is engaged in this behavior, it is automatically a violation of federal law and probably almost all state law. It also exposes you to claims by your competitors, your suppliers, your customers. Rule of reason violations. In this case, the government balances the pro-competitive and anti-competitive effects to determine whether a violation has occurred. This is the rule for almost all vertical restrictions. It also governs some horizontal restrictions where you're dealing with your competitors. So let's start with some horizontal restraints. This is where we have agreements between competitors. In this case, I just want you to pay attention to the caution. Remember I said that you can be working on different fields, okay? And so let's take, for example, and I'm just going to take an example that could be applicable to manufacturers. Let's say that you are a manufacturing company, you do manufacturing and you do some of your own finishing or your own plating, okay? That could be two different fields. You might think to yourself, well, everybody does some of their own plating or finishing. Well, they don't. There are some companies that only engage in that business. And so if you're a manufacturer, you may be in the manufacturing field, you're also on the plating field. When you are thinking about working with competitors or having agreements with competitors, be aware that you are actually working on two different fields and you need to analyze your relationships or agreements on both levels in order to determine if there might be a violation. Another common one for my clients is R&D in manufacturing. People have their own R&D. Sometimes they actually work with a competitor's R&D firm. Sometimes it's their customer's R&D firm. But in any event, you have R&D coming in and working with each other. It's an interesting question whether or not the R&D itself operates at a separate field from the manufacturing operations. In some cases, it does. And so pay attention to the relationships that you have. So when we are looking at whether or not a horizontal restraint is in place, and if you are a company that is vertically integrated, in other words, you work on different fields, you have to analyze your horizontal restraints or agreements with competitors at every level. Now, the horizontal restraints that are most common or that are per se violations, in other words, automatic violations, pretty much are what you would expect. The first is price fixing. Now, when we think about price fixing, there's sort of a sense that what that means is it means you've agreed on the price. In other words, if you've got a certain price for certain products and you agree with your competitors, that would be a violation. The law actually is far broader than the price. It does include price collaboration, but it also includes agreements on the pricing elements. So if the agreement with your competitor affects terms that affect the ultimate price, that is also a per se violation. So here are some of the issues that people have looked into and where the government pays attention. First is rebates. Another is volume discounts. You can have rebates, you can have volume discounts. You can actually go online and find out what a competitor is doing. What you can't do is discuss those with your competitor. Another is the effective date of price increases. So you've discussed with a certain company that starting January 1st, we're going to have to all increase our prices. That is a per se violation, even though it may not be a determination of a price, it's the time of a price increase. Another is cash payment discounts or credit terms. Sometimes it's allocation of fees, transportation fees that are absorbed by you and that you communicate with someone else and say, listen, let's all just do this in a certain way. Now, when I say let's all, it doesn't have to be we're doing an oral agreement on this. It's just where there's a communication, there's some kind of a coordinated conduct, and everybody institutes that new policy. So just be aware it's prices, but it also involves any specific elements of price. Next one is bid rigging. This occurs anytime there are business contracts that are awarded through a process of soliciting competitive bids, RFPs, RFQs, government contracts. Just think in your mind every time you fill one of these out, if there is an agreement with a competitor as to how you're going to be approaching this, that is bid rigging. And this is an area where everybody is paying close attention these days. So at states and at the federal level. So some of the different ways that people do it, you've probably heard of these, but I'll just give them the definition that we use in business journals. First one is bid rotation. That's where people, different companies take turns at being the winning bidder. So some bid high and one bids low and they just rotate. Another is bid suppression. That's when a particular qualified company that would bid agrees with the others that they will sit out. And again, it doesn't have to always be an oral agreement. It can just be coordinated. Why is it, for example, this is the question, why did that company sit out on this bid? They should have been in here and they didn't. And then if you start to see that different people seem to be doing it together, it doesn't have to be all 12 people who are competing for the contract. It could just be 2 or 3. But if there's some sort of suspicion about some of it, that could be the source of an investigation of bid suppression. Another is where you do complementary bidding, which is just uncompetitive bids. Somebody just puts one in that's clearly not going to be considered. Phantom bidding is when different people put in bids just to drive up the price. Believe it or not, if you're coordinating that with your competitors, that is a per se violation of the antitrust law. So when you do it when you're at somebody's auction, just as an individual, you're looking at some kind of an estate auction, people do that. But when you're dealing between companies or competitors, that is an antitrust violation. And finally, buyback. And this happens when you're using no reserve auctions. In other words, it's an enforced auction and the person who offered the product for sale comes back in and buys it because the price was too low. And in that case, that is also considered to be a fraudulent bid and consequently bid rigging, a violation of antitrust law. The next one is customer allocations. Customer allocations are just any agreement as to which customers one company will try to serve or bid for and what the other ones will bid for. It could be by name, it could be by size of the company, it could be by product line. So for example, a company might say, we'll bid on certain products for that company. They talk to they have an understanding with a competitor that they'll go after certain components, the other one will take care of the assemblies. Okay, that would be a violation. So it can be customer allocations. Territorial allocations are exactly what they sound like. So somebody says, we'll take Duluth. Somebody else says, we'll take Superior. In other words, any kind of allocation between territories. And finally, boycotts. Boycotts can be a little bit obscure. I mean, obviously, if you've got 2 people or 2 companies on the playing field and they say, we won't serve or we won't work with a certain customer or supplier, okay? That's going to be a boycott. It's just where 2 competitors agree regarding a refusal to do business with someone. It becomes a little more complicated when you agree instead, we'll just buy from certain companies. This has actually come up in the context of industry associations. It's where certain people have said, this is what we'll do. If you're a member, we agree that we will do all of a certain type of business with you. That will be a problem. That will be a violation. And so, so be aware that the violation isn't always just on who you won't do business with. That's the typical boycott. It can also be a boycott on who you will do, thus excluding competitors. And so other companies who might otherwise be able to provide the same service. And so you can determine yourself who you want to work with. But if you start coordinating activities with each other, you have to talk to an attorney and determine whether or not there might be a violation occurring at that level. Now we're going to look at the example that I just barely mentioned earlier. It's out of Iowa. I like it. It isn't manufacturing per se, but it is in the sense that it involves ready mix, something that is manufactured, let's say, or that's processed. It involved 3 ready mix companies in the Sioux City, Iowa area. There's only 3 out of many. It isn't, people did not control this market, but they were all players in this market. They engaged in a whole variety of different types of misconduct. What they wanted to do was first make sure that they were always competitive in a way where they were not going to give up market share accidentally by increasing their prices. So there was a price fixing element. I'll be reading a little bit from the case in a moment about what that involved. There was also bid rigging, which is, again, a completely different issue. It had to do with how they approached certain government bids. There was also a division of customers, which really related to territories. And they also had a refusal to bid. And that was something that was suspected and was actually proven as well. So the case is called Vanderbreak, and that's because he was the president of one of these companies. And he had been in sort of the instigator, it appeared. And so in his particular case, he had a company, it was called GCC Alliance Concrete, GCC. And again, not a very big company, but what he had done is he had been in contact with 2 other companies in the area that also provided ready mix in there for the Sioux City area. It says that among the other things that he did is he did have a meeting with one of the other people. So I'm not going to try to remember each of their names. I'm just going to say 1 company or 2 companies because it wasn't always all 3. But in any event, he had a discussion with one company where he discussed the need to get the prices up. Sounds like a pretty reasonable item. Getting the prices up is price fixing. That's the plan. So the agreement was, we're going to get our prices up. How did he do it? Well, traditionally what he had done is he had circulated his price map. Now, this is where it gets a little interesting today because people will sometimes post price maps right on their web page, okay? In this case, the agreement was, I'll give you my price map so you know what to bid, or you know what your prices should be next year. And so 2 of the companies were involved in actually just tracking his price map. In other words, the agreement was, we'll work with his price map. It was the company itself, GCC, and one of the competitors. And then what they did is they furnished that same price map to the 3rd company. The 3rd company said, we never agreed to these prices, but it was later determined that even though they didn't agree, it appeared to be coordinated conduct because their prices changed to match those that were on the price map. And so you had coordinated conduct as well as an oral agreement in that case, depending on which company you're working with. I like the language here because it says that Vanderbreak gave a particular person a price map that reflected an agreement on pricing between the 2 companies. They admitted that for the past 3 to 5 years, Vanderbreak would call one of them early in the year, give his planned pricing for the area. Now think about this, this is territory between Rock Valley and Sioux Center, Iowa, where the 2 companies' sales territories overlapped. So it's territorial in the sense of where they overlapped. The other company did not always provide its prices in return, but they followed his price list after the conversations ended. Another aspect of that was mentioned in another section. It says that, that when they talked, one of them said that he was going to increase his prices by $10 a cubic foot for the next year. Okay, so he just said, I'm just going to raise mine by $10. Now, no agreement on the part of anyone else. Okay, and it wasn't an agreement where later the government said everybody increased their prices $10. No, what it did is it let everybody know that whatever the price had been the previous year, which everyone knew, and they would have learned that even from just absolute normal competitive intelligence, when they found out what that price was this year, they know next year it's going up $10. And so what they would do is they would match it. And so one company might increase theirs by $9 in order to match it. The other one might increase theirs $12 to match it. But the idea was that they were all coordinating price increases. So it wasn't always the same amount of price increase. It was also just the final price. Bid rigging. In this case, they simply agreed that depending on the territory, some would bid for certain products or certain contracts and others would not. Now, interestingly, in some of the cases, the other companies were let go. The government decided there wasn't enough evidence to prove that there had actually been a bid rigging conspiracy. But in other cases, there had been bid rigging. So that did involve actually communicating with each other about what they were going to be bidding and then either matching it or staying out of the competitive bidding process. Divvying up customers, where actually one individual said, we just agreed that when it came to a certain part of our territory where it overlapped, they wouldn't work in it. They wouldn't bid in that area. And then finally, there was also an agreement where they actually squeezed out a company. In this particular area, there were people who could do portable mixing. And so there was a certain portable mixing company that was prepared to bid on a particular contract. And one of the conspirators contacted them and asked them, what would it take to keep you out of here? Now just think about that. That is a conspiracy now between two companies, competitors, where one of them doesn't even know perhaps that what they're doing by refusing, by giving that information, saying what it would take to keep them out of that competitive bid, that itself could be an antitrust violation. Well, what they did is they shared what they knew would be too low of a bid for them to move their equipment into the territory and actually serve a particular contract. And so he said it was $85 a yard. If the price goes to 85, we can't compete. And so one of the companies in the conspiracy deliberately bid in at 85. They admitted that they knew that they'd be taking a haircut on it, but the result was that the other new competitor stayed out of the bidding process. And in fact, it was an antitrust violation as well. There were no written agreements in any of this. It ended up with this, that Van de Breek ended with a fine of $830,000, imprisonment of 48 months with 3 years of supervised release. Now, this is a bad case, obviously, but it just goes to show that the laws will be enforced. And this is not the end of it. This case actually wound on for years, several years afterwards, because of all the claims that were brought, including a class action lawsuit that was ultimately dismissed, but where other people are still bringing claims against these three companies for what they allege to be an increase in prices driven by their collusion. What is horizontal restraints that are governed by rule of reason? Remember, not all agreements between competitors are per se violations. Some are based on a rule of reason. These are agreements between competitors that are often found in joint venture agreements, manufacturing agreements, joint development agreements, licensing, and other agreements. If it is a non-per se restraint, in other words, not an agreement on price, or it's bidding, or territorial allocations, the restriction may be permitted if it enables competitors to offer lower prices, improve quality, or bring new products to market faster. Remember at the beginning, I said the objectives of the law are fair and presumably or hopefully lower prices, better quality and innovation, and efficiency as bringing products to market faster. Excuse me. Here are some examples of agreements between competitors that have pro-competitive effects. It doesn't mean that they're going to always be legal, but it means that the companies that are involved in them have a very strong argument for saying that under the rule of reason, their agreement is enforceable. Excuse me. Agreements where you combine one company's technical expertise with another's skills in manufacturing processes. I draft these agreements frequently. Another, combine our R&D to reduce costs or the time to develop and bring new products to market. This is common as well, because in these agreements, I'll often be discussing, as we work on this, who's contributing which IP or intellectual property, who's bringing in other intellectual property, how they're going to be able to keep their respective property, and who's going to own any new property that's developed out of it. You probably run into this in your agreements also. Another is where you might combine marketing. This gets a little more dicey because you might be thinking, okay, well, that means price, but it might not be that. It might actually just be where you're coordinating certain types of marketing activities in order to bring new products to market or to increase just your ability to work with each other. Another is to combine assets to invest in improvements to the processes or outputs of both. Somebody says, you know, we're trying to put in a new line. Okay, in order to make this work, why don't we work with a competitor and maybe they'll send us some of their work, or we'll do something else that involves some kind of investment where it could also be through a joint venture agreement and investment in improvements. And finally, something that attains economies of scale that neither of you could afford on your own. Next, we'll look at vertical restraints. Now, again, the question is, what will the effect of this be something that increases quality or not? And generally speaking, in vertical restraints, again, this is now between people on different fields, different levels. In most cases, these are not going to be a problem. In other words, the vertical restraints that you have with people on different fields, in different games, those agreements are to be expected. So let's just take raw materials, an agreement between a raw materials supplier and a processor. Agreement between a processor and manufacturer, manufacturers, distributors and retail sales. All of these involve, these are vertical contracts, and we'll discover that in most cases, any restrictions in these contracts are governed by the rule of reason. There's one exception, which is tying. So we're going to first look at the issue of tying. What does it mean? Because it's the one per se violation that you will find when you are working with with vertical contracts. Tying is a per se violation. It occurs when a company, and here I use the manufacturer or supplier, requires its customers to purchase a less desirable tied product in order to obtain another more desirable tying product. So where might you see this? I don't see it often in just manufacturing agreements themselves or even supply contracts, because usually people agree on a variety of different products that they might be buying, whether it's raw materials or it's processed materials, maybe finishing, whatever it is, you're working with a variety of different items. But sometimes people will add something from a different field. And they'll say, for example, if you want to purchase one item, okay, let's just say you're going to provide a certain component, okay, or a certain maybe assembly, then you also have to purchase our service contract. This becomes a bigger issue when you're working with OEMs. But if you're in a situation where somebody is offering a tied product or service with another one that is the tying product or service, that's a per se violation. You're forcing someone to buy something they don't want. Now, there's no violation if what you are doing is having an agreement where two companies are working out arrangements where you're purchasing a variety of different items. You're buying the maintenance or service contract. You're also buying certain products. Maybe you're providing certain R&D services. In other words, you're providing a variety of different items in one contract. As long as it's something that's offered and negotiable, that's perfectly fine. It doesn't matter if you include multiple items, different fields in the same contracts or in different contracts. The problem only arises if you say you can only get what you want if you also buy another item. Those can be per se violations. I only say can be because once in a while, a person can demonstrate that that was not actually a tied contract. All other vertical restraints, and we're going to look at some now, are governed by the rule of reason. Again, it's balancing, anti-competitive versus pro-competitive. So price restrictions. You'll see this every time you go on to a car dealership, but it also happens in other contexts. It happens in distributorship agreements frequently. It's where there are minimum or maximum resale price maintenance clauses. We call those RPM clauses, resale price maintenance. And so typically what you'll see in a car dealership, it'll say manufacturer's suggested retail price. It's in order to avoid a risk of an antitrust violation by dictating the price. There are certain areas where you can have maximum and minimum resale price, but it has to be reviewed legally because the risks become more significant as you impose tighter constraints on what the price can be. This is a vertical restraint between a distributor and a retail. It might be at other levels too. Anytime you have any kind of restraint in the agreement as to what the buyer is going to be able to offer it to a third party, that becomes RPM. The next one is where you have restraints on discounts. In other words, the agreements provide for certain discounts where it has other price elements. The one I see that creates some problems potentially in the antitrust context, although it seems to survive it now. I'm not sure it will always in the future. Most favored nations clauses. You'll see those as well. That's a vertical restraint between companies like a supplier and a manufacturer, and the agreement is that the supplier will always give us, the manufacturer or the OEM, will always give you the best price. That is a vertical restraint involving price. It's governed by the rule of reason. So just because you've got it in place and the rule of reason governs doesn't mean it's going to actually be enforceable. The question is the anti-competitive effect, does that outweigh the pro-competitive effect? And then you have non-price, and you'll always recognize these. These come from any distributorship agreement, territories, quotas, okay? So those are governed by the rule of reason. Again, you have to compare the different effects of it, but then you can also add benefits. Some people offer discounted maintenance, free advertising, and some add services. They might just say, well, toss in certain some extra service, whether it's maintenance, R&D, some assistance with getting your new products out. That might be more on the order of a marketing agreement. But the idea is that these are vertical restraints. You have non-price controls, and it affects, it is affected by the antitrust provisions. All right. All right, now we are moving to an antitrust compliance policy. In this case, I'm just going to show you a recent one. This is not a form, but it's something that's helpful. It's a single page. In this particular case, it's used by the entire company. And when I say this case, there are actually other provisions as well. It consists of 3 different paragraphs, and so we're going to take these by paragraph. The first one is just the introduction. This is what would be the kind of policy in a general way that governments are looking for. It is a policy of the company to conduct all of their activities in full compliance with federal and state antitrust laws. Okay, see, it's the company and affiliates. So be aware when you are purchasing or when you're working with subsidiaries or other related companies or other offices, you have to have this in place for all of your employees. In the course of their duties, now by that I mean the employees certainly that work or interface with competitors. In the course of their duties, all employees must refrain from activities that may unlawfully restrain competition and must consult management or counsel for guidance when they are uncertain about what is proper. In particular, employees must avoid agreements with competitors. So, employees, that's everyone who's an employee. Okay, it isn't just the people who are working, for example, in sales. You might have people in your R&D department who are working with another competitor's R&D group. That is a potential problem. So be aware, it's not just always salespeople. It isn't always just management. It can also be people in your R&D group. It'd be anyone who is actually working with competitors. So the first thing is that. The second is it's all employees who might be in that situation. So make sure you're keeping track of which employees, whether it's full-time, part-time, temporary, you got to make sure that everybody is covered. You must avoid agreements. Now, this is where training comes in, because agreements don't just always have to do with something in writing. It's also just the oral agreement that 2 people might have from 2 different companies in your R&D group. And it has to do with any of the following. So you must avoid agreements regarding the following. The prices charged for any of our products or services. So just keep that out of the discussion in every department when you're dealing with a competitor of any part of your company. This includes any increase, decrease, or discount in prices. In other words, elements of price, and also what constitutes a fair price. Also, the terms of any bid or response to requests for proposals. If you're working, or if one of the employees in your group is working, let's say they're an engineer and they're working on an RFP. They happen also occasionally to be working on other projects with a competitor. They can't mention anything about the proposals that they're preparing in response to some outside party. If they start talking about it, that could end up being an antitrust violation. The discussion doesn't always rise to the level of an automatic antitrust violation. But as soon as people are talking about it and somebody acts on it, you've got a problem, a serious problem. Also, if it's just suspected that they might be, it could lead to an investigation. Now, add to that the fact that people might be getting rewards for having reported suspicious activity. Next, the prices at which we purchase supplies or services. Next, the allocation of markets, whether by sales territories, customer class, or type of product. We just don't discuss how we handle different areas of the country. So for example, when I work with clients that have sales reps in different parts of the country, and they have different arrangements with different sales reps in those areas, independent sales reps, we don't ever discuss what those terms are with other companies like us that we relate to on a daily basis. In this case, medical device. They don't talk to other medical device companies about what they're paying or what their arrangements are with any of their other independent sales reps. We don't have a refusal to deal with any person. Remember, it can be a refusal to deal, but it also can be coordination to deal only with certain people, especially a customer, supplier, provider, or competitor, or a class thereof. I like to just throw this in. This also includes boycotts of professional services. Sometimes you'll have people say, we don't like working with, let's say, a certain quality company. This company has done just a terrible job. Let's just agree, or I think you shouldn't work with them. And the other company goes, I agree. If you don't like him, we don't like him. If we don't like that insurance agent, if you don't like him, we won't do it either. That's actually an antitrust violation. So a refusal to deal by agreement between competitors, even if it isn't someone in their playing field, but in a different field, that is a boycott. Another will be that you don't discuss what products or technologies will be offered or not offered to customers. Why? Because that sets up the risk that you're going to actually end up, in some cases, allocating customers or products between each other. And finally, other competitively sensitive matters such as information about strategic plans, market share, profits, margins, and costs. Now, generally, that information is already prohibited under every one of your non-disclosure agreements, your employee confidentiality agreements. It'll be in your employee handbook. One of the reasons for it, which you may not be aware of, is in part to protect your company against risk of antitrust violations, or at least that's the effect of it, even if you're not aware of it. So just be aware that particular information is something that needs to be kept out of the hands of your competitors, in part to avoid violating antitrust law. Finally, the last paragraph of that agreement is employees will write carefully and clearly. This is just good policy anyway, not just for antitrust reasons, but you need to be careful and clear, and you assume that everything written may be disclosed publicly in an adversarial proceeding. These rules apply to employees engaged in informal or social discussions. That includes industry association meetings, obviously, but it could be engaged in informal or social discussions with representatives of competitors, as well as informal on-the-job settings. So part of the training is you don't want your people to be discussing any of these issues at the company, at a competitor's place of business, or when you're actually interfacing with them in a formal setting. You also don't want to talk about it at an industry trade show or at any industry association meetings, any place where you might be communicating with these people. There was a case that came down some time ago where it was a discussion where it actually happened that a family member in a small company, a family member was working for a competitor, and that individual picked up the price list and other information, brought it home and showed it, I think it was to the father-in-law, to show what his company was doing. And there was an antitrust charge brought. The dad or the father-in-law demonstrated he didn't ask for it. He said he didn't even know about it. It was just stuck on his desk. And so we're not really sure, that seems like kind of an interesting defense. I didn't know what my son-in-law was doing, but that was the defense, and he was able to survive an antitrust charge. So I just want you to know, keep track even of the people who who might be working for competitors. Don't solicit that information if they're working for the competitor. general, your general, I'll call it, your competitive intelligence is good, but you have to be careful about where you're getting it so that it doesn't become a source of a potential antitrust violation. Okay, and it just tells people if there's an issue, consult your manager. Next, I'm going to move to the business card. We're almost finished. And so in this particular case, this is just, I think, a very good handy add-in that business cards can be helpful, again, in demonstrating compliance or a policy of compliance with federal and state antitrust law. This is an example of a company. I've edited it, but this is given to all sales and management people, and that includes supervisors. And it just is a card they're supposed to keep in their wallet. In the course of your duties, it's sort of like the 10 Commandments, but a lot more than 10. In the course of their duties, all employees must refrain from activities that unlawfully restrain competition, okay, and must consult management or counsel for guidance when they are uncertain. Observe the following compliance rules. So this is a little firmer within the company than the law actually might require, but these are good rules. Do not discuss prices or terms of sale or any elements of price with your competitors. Do not discuss projects up for bid or agree not to bid. Again, that's bid rigging. Do not discuss customers, production territories, or markets. Why? Because it invites an agreement or collusive activity. Do not discuss prices you will pay for products and services you buy with others who buy the same things. Don't agree to boycott or refuse to deal with suppliers, customers, or competitors. The obvious one, just by way of reference, is let's say two companies are talking about doing something in a collaborative way, and they say, let's go talk to one of our competitors, okay, and see if he'll join us. Obviously, that is where people are agreeing. And then when the third party says, hey, I'm not going to do what you're doing, I think that's a violation of antitrust law. The first two say, well, then we're not going to work with you anymore. Okay, they've now boycotted and they're inviting an antitrust violation. It says this applies to all products and services. Just as a reminder, it isn't just manufacturing, but it's any of the services you obtain. Do not use your strong market position to exclude competitors. Do not require your products to purchase one product to obtain a less desirable product. That's tying. Don't arbitrarily offer one customer prices or territories more favorable than you offer the customer's competitors. Okay, now, this actually is dealing with Robinson-Patman Act issues, so I won't go into it, but there are defenses, and that is if you are trying to compete or respond to a competitor's lower prices. The idea is that you're going to offer a fair price to everybody. It doesn't have to be the same price, but it has to be fair. And if you're going to be offering more favorable prices or terms to one company than another, and it involves interstate commerce, okay, so this is where you say, okay, Minnesota gets one rate, Wisconsin gets another, or you just say Eastern US gets one rate, Midwest gets another, okay, you have to evaluate to see whether or not you might be actually violating the antitrust laws under the Robinson-Patman Act. I'd be happy to talk to you about that if that's a question. Do write carefully. Again, this is just a response about being careful. And do know that the antitrust rules apply in social settings, industry conventions, and trade association meetings. They actually asked to have that highlighted. Consult management regarding antitrust questions or concerns. Report to management any antitrust violations you observe. Okay, it involves customers, suppliers, competitors. That's obviously the outside people. If you see something that looks like an antitrust violation, you're not sure about it, report it. But it also can involve coworkers. And the reason is, first, you got to make sure the process, the violation stops, and people are properly either trained or disciplined. But in some cases, if it's particularly serious, with lawyers' guidance, you may wish to actually self-report. That occurs in other areas too. For example, violations of the laws governing defined benefit plans for your employee benefit plans. But in this particular case, you can avoid a lot of liability in some serious cases by actually self-reporting. Again, only with an attorney's advice. Other possible sources for antitrust policy, I've mentioned this along the way. Not everybody does it as a separate policy, but you'll see it in employee handbooks. Make sure people are signing for it. Again, it should be accompanied by training. Second, fraud prevention policies. So I've seen these in policy groups or policy manuals where it talks about things like the Foreign Corrupt Practices Act, and then they'll also include an antitrust term in there as well. And finally, this is the end. What if there's prior to your questions, what if there's an investigation or complaint? Now again, first, let's start with the one that's directed at your company. you get a complaint, either from a letter from a competitor, or you get something from one of the federal offices or state offices. The first thing is drop down to the bottom of this slide, call management, okay, and then you should call counsel. Also, in some cases, people should just know if you've got a fraud prevention hotline, it's where they should report that they've gotten this information. Best thing though, contact management. Next, not only if there's a complaint about you, okay, what if you discover that someone else is making a complaint against a different company? So you find out that two people who you've been dealing with that you know, and maybe that you do work with, somebody is involved in some kind of investigation or complaint. Be aware people are looking at who they did business with. And so when you find out about an investigation or complaint of someone outside your company, don't just breathe a sigh of relief. If you're working with them, notify management, okay? Because someone needs to make sure that you weren't somehow inadvertently drawn in. Next, what if you're approached by someone or learn of someone making a suspicious or illegal offer? This will generally be a situation where you have someone out in the field, maybe it's an engineer, maybe it's a person maybe it's someone in sales, and someone approaches them or gives them information that sounds suspicious, like this is information I shouldn't know, information you shouldn't be sharing, information that maybe is clearly what it sounds like an effort to try to coordinate conduct. If someone is approached or learns of someone making a suspicious or illegal offer, again, call management. Don't put it off. Don't say, hey, I won't talk about it. I know in my mind I shouldn't be dealing with this, so just don't tell me anymore. What you need to do is report it, because that way you'll be able to head off any future complaint that you somehow were involved with it. Okay, with that, I'd be happy to take questions. And Amy?
Yes, thank you, Mark.
Okay, yes.
Thank you. I do have a quick question here in chat. What if you own two different businesses and they work together to produce products? Is this a gray area?
No. If it's same ownership, it's not a gray area for your companies to be working with each other. Shared ownership, shared control. You want to make sure that's really the case. But in that case, you can work under the same umbrella. It's just that you have to pay attention to what each of those companies is doing outside. Okay, and that no one else is involved in any kind of neither company is involved in any kind of collusive activities with those outside. But also be aware, if an antitrust claim is made against one, you're likely going to be pulling all your companies into that antitrust violation.
Thank you.
Mm-hmm.
Another quick question, if we may. If you're dealing with companies in different states,
Mm-hmm.
how do they decide which jurisdiction covers it, or do they all get involved, including federal laws?
Usually they can get all involved. What will usually happen is that the person who's making the charge will start by bringing the charge in their state. But technically you can have multiple states involved depending on the scope. And the federal, yes, the federal can get involved. What you'll often see is that there will be sort of a coordination between governments and a decision as to which area they're going to, which laws will apply first of all, because sometimes that makes a big difference. And that may be determined by an actual court case. A certain court will come in and say either it's our jurisdiction or it's not. But once you've established the jurisdiction, everybody can be involved in that particular case. And yeah, you're not limited by just one. So you could be exposed in multiple states.
Thank you. All right, time for one last question.
Okay.
Do you know of any small companies that lost when they had a joint venture?
Yes, there is a case where 3 bus companies decided that they were going to create a joint venture. This was actually fairly recent. And what they decided to do was they said they could offer more efficient transportation options, less expensive options if they work together. And so it would involve also sharing of resources. So it was really what appeared on its face to be a very legitimate, pro-competitive, I'll say, agreement. But the courts came down and said, no, the real benefit of this particular agreement was that everybody was able to figure out what basically it was that group that that then would bid on different bus routes. And the government came in, or the courts came in and said, no, the real benefit wasn't for the for all the different routes that were out there and for all the different people who could get more routes. It was really meant, or the real benefit was to the people because they could control the price at which they were bidding. And so that one was struck down.
Well, thank you very much, Mark.
Okay.
Thank you. Wade? Wade, do we have you?
Yeah, I can't start my video.
Oh, okay. Well, we can hear you.
Okay. At this time, I'd like to give a big thank you to Mark for giving his expertise with us today. And it was very informational. I really enjoyed it, Mark, so thank you. I'd also like to extend gratitude to our members for your continued support. And this webinar is coming to an end. So for those that are logging off, we'll see you again next time. So have a great day.